litigated the Hunter Biden various cases, was also appointed directly from out of government. Now, that distinction between being appointed from out of government and being appointed in government is one that is critically important for the statutory interpretation. It's also a bit of a formality, because what this decision means is that if it's correct, that Jack Smith could not have been directly appointed as special counsel. However, there is no dispute that the Attorney General has the authority to hire Jack Smith as a regular employee, and then 1 second later appoint him as the special counsel. And so this really does come down to a matter of extremely thinly sliced technicalities. So the decision is limited in those respects. Now, it's also true that it extends far beyond the special counsel. The reason is because the special counsel is not the only inferior officer in the Department of Justice. The arguments that Judge Cannon adopted in this decision apply to all inferior officers within the Department of Justice. We don't know exactly which officials in the Department of Justice count as inferior officers, because it's never been litigated. But I think it's fair to say that the list includes, at the very least, the Principal Deputy Solicitor General, the Deputy Assistant Attorney Generals across all of the different component divisions. So the Deputy Assistant Attorney General of the Criminal Division, the Deputy Assistant Attorney General of the Civil Division, the Deputy Attorney General of the Antitrust Division, and on and on. Now, the example of the Principal Deputy Solicitor General is one that I find particularly striking, because the Principal Deputy Solicitor General argues before the Supreme Court maybe a half dozen times a year, and is frequently the acting Solicitor General, because the Solicitor General has to be confirmed by the Senate, which means, at least according to Judge Cannon's decision, that the United States has been represented before the Supreme Court by an unconstitutionally appointed official for decades and decades, and not a single justice of the Supreme Court noticed. I find that to be particularly striking, and it's also an indication of the potential sweep of Judge Cannon's decision.
Josh, do you agree or not about that potential sweep? How broadly do you think the reasoning sweeps? And tell us whether it has been adopted by any other Supreme Court justice beyond Justice Clarence Thomas in his concurring opinion in U.S. v. Trump.
I think Matt makes a fair point about what are called the DAGs, the Deputy Assistant Attorney Generals, and the Deputy Solicitor General. This is a problem, I think, for the theory advanced by the Mies amici. It's actually not a problem for the Blackmun-Tillman position, because we actually don't think it makes much of a difference whether this position is principal or inferior. We don't actually focus on that. In our view, what matters is whether you're an officer. And there's a line of cases going back to the 19th century describing certain facets of what an officer is. And one of them, it has to have continuity and duration. It doesn't mean you're in it for a long or short period of time. It means when your task finishes, when the purpose of your appointment finishes, does the office continue? And if the answer is yes, that's a pretty good sign that this is an office. So the position of a DAG or Deputy SG, in our view, is an office. And so I think it can exercise these powers without any problems. The problem for Jack Smith, though, is that we don't think he has an office at all. And this is one place where there might be some distance between us and the defendant. The reason why is Jack Smith was appointed for a particular purpose. You can read the letter. He's to investigate certain things that arose out of J6 and maybe related matters. And when those are done, his position just dissolves and vanishes in a poof. The judge, I think, focused on the fact that this went on for a couple of years, which is certainly true. It's been dragging on, I think, forever. But that's not, I think, the relevant test. It's, does this position have duration? Does it have some way of continuing beyond the present order? In our view, no, it doesn't. It's over once. If Trump were to be pardoned tomorrow by President Biden, it's going to happen, right? If President Biden pardoned Trump tomorrow, Jack Smith does have a job. There's maybe some other people can indict, but he's done, right? So in our view, he's not an officer at all, and that doesn't pose any problems to the DAG and Deputy SG example that that Matt mentioned a moment ago.
Matthew, tell us about Justice Thomas's concurring opinion in U.S. v. Trump. He says, I am not sure that any office for the special counsel has been established by law as the Constitution requires. He doesn't definitively tell what he thinks about the question, but Does Justice Thomas's reasoning sweep more or less broadly than Judge Cannon? And has any other justice on the U.S. Supreme Court adopted Justice Thomas's position?
The concurring decision by Justice Thomas that you reference was in the immunity decision that was decided on July 1st in the January 6th case. And then the decision by Judge Cannon was in the Mar-a-Lago classified documents case. But that's not the only case against former President Trump that is being prosecuted by Special Counsel Jack Smith. There's also the January 6th case. And as Josh mentioned, the appointment letter of Jack Smith says that he has these two different portfolios, the classified document situation and President Trump's involvement in the January 6th events. So the Supreme Court held that a former president, including former President Trump, is immune from some set of his official acts while taken in office. Absolutely immune for those acts that were taken within certain core executive functions of the president, and then presumptively immune for all official acts. And so this was an issue where the district court in DC had denied this immunity. The DC Circuit also denied this immunity, went up to the Supreme Court. The Supreme Court says, actually, there is this immunity, and sent the case back down to determine whether the conduct alleged in the indictment in DC falls within the scope of that new immunity that the Supreme Court established. Now, in the course of that decision, Justice Thomas issued a concurring opinion that addressed this issue, which was not briefed in the DC case at all, but is potentially an issue in both the DC case and, as we know, the Mar-a-Lago case, which is, Jack Smith was the prosecuting attorney for the DC January 6th case. And so he was sitting at counsel's table in the Supreme Court for the immunity decision. And so the question might arise, okay, so does the DC case completely go away in the way that Judge Cannon says the classified documents case? So now this issue was not raised in the DC case on this appeal. The reason is because it hasn't come up yet in the DC case. But nonetheless, Justice Thomas asked a question about this at oral argument.
Did you, in this litigation, challenge the appointment of special counsel?
And then he said in this concurring opinion, he didn't say necessarily for sure that the special counsel is not lawfully appointed, but I think he signaled pretty strongly that he would probably hold that if the issue comes to the Supreme Court, which I think eventually it probably will. Now, the key question, though, is whether any other justice agrees with Justice Thomas. We don't know for certain. No other justice signed on to agree with Justice Thomas's concurrence. No other justice on the Supreme Court in the immunity decision said anything at all about this appointments clause issue. That doesn't necessarily mean that they don't agree, but it is a bit of a signal. It's also, I think, fair to say that the appointments clause position adopted by Judge Cannon has been a minority position. How much of a minority position, I think you can probably debate, but it's certainly not been the mainstream position. So I think it's unlikely that a majority of the Supreme Court would ever agree with Judge Cannon's decision. Josh may disagree about that, but whether it's one or two or three justices that ended up agreeing that the special counsel is unlawfully appointed, I can't really say. It's possible, but we Supreme Court litigators say that there's really only one rule at the Supreme Court that matters, and that's the rule of five. And can you get five justices to agree with your position? I think that's going to be a really steep hill for the opponents of the special counsel's appointment to climb.
Josh, do you agree or disagree that this is a minority position on the Supreme Court? Justice Thomas, and we don't know how many more justices. And then, address this question: is it the job of lower court judges to predict the law and to embrace positions that have not been embraced by a majority of the Supreme Court, or not?
So it's often said that the DC Circuit is the second highest court in the land, and perhaps that's true. But they've also developed their own body of case law over the decades. And I think there were a number of decisions from the 1980s and 1990s where the court basically looked at United States v. Nixon, and presumed that this decision authorized this idea of these outside people being appointed to these special counsel positions. And as an original matter, I think those cases are probably wrong for reasons I mentioned. I think they misread Nixon, but those precedents built up over the years. So it's unsurprising when all these district courts in DC reached the same conclusion, they were bound by the same DC Circuit precedent. We're now in Florida. We are next to the Atlantic and not the Potomac. And I think there's a different set of precedent that applies. I think Judge Cannon's decision, I don't know that I agree with it in all regards, but I think it at least advances a plausible reading of Nixon. I think there are other readings you can adopt as well. And then once you get over the hump of does Nixon control, I think there's some very difficult statutory questions. And again, lurking in the background is a case we haven't mentioned yet, maybe in passing, is Morrison against Olson. Right? This was this landmark case, 7-1 decision by the court upholding the independent counsel statute. Justice Scalia wrote, I think, one of his most important dissents ever, where he said, "This wolf comes with a wolf. This is unconstitutional." I'd wager there are 5 votes to overrule Morrison, maybe 6 votes. I don't know. So when you're asking how many votes did Justice Thomas get, perhaps as a stopgap of overruling Morrison, they go with this sort of narrow statutory question. And the court always likes to say, we're not going to do constitutional. We're going to do narrow statutory things. It's a major question. I don't know. Make something up, right? So who can predict? But the question, of course, is the election. We don't talk about elections, but we do in this context. If Trump wins, the AG gets fired. The AG fires Jack Smith on day one. The prosecution vanishes. Maybe Trump pardons himself. I don't know. And we don't have to decide this. If Trump loses, then Jack Smith goes full steam ahead with a trial. In fact, Smith might have a trial in December, for all we know. He could have it this year if Judge Chutkan moves fast enough. Then this case will go to the Supreme Court. At that point, Trump is no longer a viable political candidate. And maybe the court says, all right, whatever, right? If we rule in favor of Trump, what's going to happen? Won't be Bush v. Gore. So I don't know. I'm very bad at predictions, usually wrong. But lots of stuff can happen with this case.
Matthew, do you agree or not that there might be 5 votes to overrule Morrison v. Olson, and then return to this question of how radical this decision is? How broadly would it sweep if the U.S. Supreme Court were to affirm Judge Cannon and Justice Thomas and agree that Jack Smith is unconstitutional? How many other special prosecutors would be called into question?
I agree with Josh that Justice Scalia's dissenting opinion in Morrison has certainly convinced a lot of people. I think there's a pretty decent chance that there's 5 votes on the Supreme Court to overrule Morrison v. Olson. I think that fact also illustrates some parameters about how we should think about lower courts applying Supreme Court precedent. So the 2 parameters that I'm thinking of are, one, the Supreme Court has said on numerous occasions that it reserves for itself the sole authority to overrule its own precedents, and that lower courts should follow Supreme Court precedent unless and until the Supreme Court itself overrules that precedent. And you can understand why that principle is really important for an orderly judiciary. So what the lower federal courts are not supposed to do is say, well, I think times have changed. There have been some really persuasive law review articles that I think might convince a majority of the court, so I'm not going to follow this on the books precedent because I'm predicting that the current Supreme Court would rule differently. That's not the way, according to the Supreme Court, it's not the way that lower courts are supposed to treat Supreme Court precedent. So that's one parameter. The other parameter is that, sometimes there's some fuzziness about whether a case has been overruled or not, whether its underlying rationale has been undermined, etc. And so there are situations where lower courts are put in the challenging position of trying to figure out, okay, so how much am I bound by this prior case? Has the Supreme Court really abrogated it in some way? But when lower courts, and this is the second parameter, when lower courts are evaluating that question, they have to be really careful about making sure that they look carefully at what that prior case actually held if they're going to say that it's been implicitly overruled. And Morrison v. Olson is a perfect example of this. Morrison v. Olson was a case that upheld the independent counsel where there was a statute that passed by Congress that limited the president's ability to appoint and then remove that special prosecutor. And so the issue that was raised in Morrison v. Olson was about the interaction between Congress and the president. That issue is not posed by the special counsel now. Anyway, And the reason is because the special counsel's protections against being fired, can only be fired by cause, it's not a congressional statute at all. The Attorney General has promulgated some regulation that says, as a matter of policy, that I'm not going to fire the special counsel unless they're